Hi, welcome everybody. Welcome to another program for our Law and Technology Initiative. We've got a full room here in person here at Northwestern. I don't know, we've got 70, almost 80 people in the room here, and we're expecting a really good turnout on Zoom. So thank you for joining us for this hybrid event. I'm Dan Linna. I'm the Director of Law and Technology Initiatives and also a Senior Lecturer here at the Law School at Northwestern and also in Computer Science at Northwestern. So we're really excited to put on this event. It's co-sponsored by our Center on Negotiation, Mediation, and Restorative Justice, and also two of our student groups, Intellectual Property Law Society and High Tech Law Society. And I think, Saya, you were gonna say something about HTLS, okay. Sure, yeah, and the mic should pick up in the room, but just, okay, sure, just.
Hi everyone, my name is Tashea. I'm the director of events for HTLS, the High Tech Law Society. We throw events throughout the year for students interested in the intersection of law and technology. And we're going to be at the student org fair from NBC.
Oh, it's not picking up, so, but.
No,
just briefly.
Hi everyone, I'm Saya. I'm the director of events for HTLS, which is the High Tech Law Society here at Northwestern Law. We throw events throughout the year for students interested in learning more about the intersection between law and technology. We're going to be at the Student Org Fair on September 15th, so if you're interested, come say hi.
Thanks, Saya. Okay, Intellectual Property Law.
Yeah, hi, I'm Joe Previty. I'm one of the co-presidents of Intellectual Property Law Society, or IPLS. So if you have any interest ranging from art law to copyright to trade secret to trademark to patent, we're looking for people who are interested in all aspects of IP. So you don't need an engineering degree to do IP. You just need an interest really to do it. So we'll also be at the org fair. So we're really looking to meeting everyone, and hopefully you can be excited about some IP.
All right. Okay. Thank you. All right. So we've got a great panel joining us for this program, Technology Adoption in Courts, Promise and Pitfalls for Access to Justice. Amy Schmitz, a professor at the Ohio State Moritz College of Law. Jason Tashea, a Schmidt Innovation Fellow at Georgetown University Law Center. And Oladeji Tiamiyu, who is a Senior Clinical Fellow at Harvard Negotiation and Mediation. Just wanted to briefly tell you a little bit, just for a second, about our Law and Technology Initiative at Northwestern. It's a partnership between the computer science and the law school, and also external partners, right? So programs like this are really important. External academic partners, partners in law firms, legal departments, legal technology. We do events like this. We have courses. We do training workshops and research as well. Now, for this event, the Zoom chat is open, but what we'd really encourage you to do is use Slido for comments. So in the audience here, please go to sli.do Slido and use NULTI. If you use the code NULTI, I think on the next slide we've got that, but if you're at sli.do, then you can join there using that code. David was maneuvering between dropping the link, so the link is in there for people on Zoom. So we're going to have time for discussion, and we want to use Slido, and you can engage in a discussion on Slido, so please use Slido. So with that, I want to just jump straight into our first talk. And for that, I'm going to turn the floor over to Jason Tashea. Jason.
Thank you very much. Let me get my screen up. And if I can get some head nods indicating that you're seeing a slide with yellow and white, great. All right, Dan, thank you very much for having me, and thanks to Northwestern for putting this all on. So as we all know, the pandemic accelerated a bunch of existing trends around the globe for better and for worse. Work from home, migration trends, hybrid events like these, they've all become much more common, even though they existed before the pandemic started. And this is entirely true in regards to court digitization as well. Initially started as an exigent circumstance in March of 2020. We've now seen courts begin to really lay into what a digital court could look like. And for the past 2 years, I've been looking into what justice digitization looks like for the World Bank around the globe. And I'm happy to say that the level of experimentation and adoption of new technologies, especially those that help the public, has never been higher. However, with all of this rapid adoption that we have seen, problems are becoming clearer and solutions that needed support for continued growth in court digitization and access are becoming more apparent. So today, what I hope to do is to give you a quick landscape of what's going on around the globe in regards to court digitization and access to justice. And then I'd like to talk a little bit about what's not working, and then 3 possible solutions to get at structural problems that can help not only improve courts do their job, but also improve the public's access to those institutions. So first off, what is happening? And for this section, I break it into 4 different categories or layers, each of which that I'll define and then offer a few examples. So I'm going to start with the information layer. This is the data layer. And as anyone who's doing any work in technology today knows that data is the lifeblood for everything else that we are working on. What we are beginning to see are things like data standards, new digitization and collection efforts, and automated deletion. In the US, this looks something like the National Center for State Courts, National Open Courts Data Standard, which is beginning to be implemented at the state level. And this is essentially data standards, for those not read in yet, is how data should be represented and how it should be shared so that everyone is on the same page. In Africa, there's the African Legal Information Institute that's working in common law countries like Malawi, Sierra Leone, and Zimbabwe, working on digitizing court records and regulations. And in that process, they're even creating a universal citation system that's beginning to be used across those jurisdictions. When it comes to digitization, we see courts in Moldova, Kyrgyzstan, Southwest Nigeria, all taking their historic paper court documents and then making them accessible digitally. And now, as that data is being collected in the information layer, we then have to talk about what trust and consent looks like. Like, how do you secure that data and the people, the data subjects that are represented within that data itself? In my personal view, this is where public trust and confidence in courts lies when it comes to the digitization process. And it matters because courts are regularly getting hacked. We've seen it happen in the United States at the state and the federal levels. Brazil's courts have been hacked, international tribunals in The Hague. They've all become targets because of the information that they have. Now, when we're talking about this issue globally, this tends to be a topic that's controlled state by state or country by country by whatever data privacy law that country has. Of course, we are not lucky enough to live in one of those countries, so I will put America to the side for this part of the talk. But where countries do have established and mature data privacy regulations, they tend to impact how courts think about their data should be accessed by the public. So 2 quick examples. In Estonia, they took the General Data Protection Regulation, which is the EU's big data privacy law, and they decided that that meant that you could not scrape court data. So they added a CAPTCHA to the court data website, so you couldn't go in and automatically take the information that's there. You had to go individually and manually case by case. In Chile, something similar, their data privacy law led the court to determine that no companies looking to profit off of public court data should be allowed to do so. And they've gone as far as actually criminally prosecuting companies that did try to build a business model off of public court data. And then when it comes to security, the most impressive model that I came across was, again, in Estonia. We're going to come back to Estonia a couple of times, where they have created a data embassy, literally an entire digital backup of their government, and they have housed it in Brussels. So if a cyber attack hits their country and it all goes down, they do have a full backup, which includes their courts themselves. Now, once you have the data collected, you've decided who has permissions and access to that particular data, you then need to think about how is that data going to move? How is it going to be managed? And how are people actually going to get in there and access it? This layer is the connective tissue of court digitization. It's what brings everything together. It is also, as far as I can tell, the least developed of the 4 layers that I'm going to talk about today. But there are good examples of things that are going on. In Kenya, their commercial courts went from having a 40-day window that it took to both file and serve for your commercial case. They decided that was bad, and they created an online portal where people could upload their documents, they could pay, and they could be assigned a case. And now it takes just 7 days to file and serve in Kenyan commercial court, which is quite the improvement. Again, in Estonia, which probably has the most mature tech stack of any court in any democracy in the globe, has a digital ID system that's provided by the federal government or their central government, but they also have what's called the X-Road system, which is the software that every agency in Estonia uses. So everything is standardized and you can offer permissions either internal to the agency, so different people can access or not access certain information, but also across agency. So if you have a human welfare agency that needs access to court documents or vice versa, that is baked into Estonia's court system, which is all very quite impressive. And then last, we have the services layer. And this is probably the layer we think most about when we are thinking about court digitization, because this is the layer that we interact with. This is the front end interface, while the other three layers I've talked about are more back end, kind of the stuff that IT handles. This is what we think about when it comes to access to justice work. And it has an administrative component, internal facing, and then a public facing as well. On the internal side, we look in Brazil's courts. They've created the Victor program, which is a machine learning model that took all that data from the information layer of appellate court cases and created a triage tool to find points of law on every case that came up on appeal so that the courts could more quickly assess where a particular appeal needed to go. On the public-facing side, Ukraine created the Online House of Justice, which is an online portal for the public to be able to access reissued government documents like birth certificates and marriage licenses. Here in the United States, we have the Maryland Judiciary's Court Help Out app, where they have digitized all of their self-help resources and put them into one centralized place. Now, this is an entire whirlwind world tour that you just got, but I think the one takeaway is that we are not short on examples of courts trying to modernize and update their processes. However, these changes are helping us see different cracks and shortcomings in the form and function of what courts are trying to do. And at its core, these challenges, it's because courts are being asked to do more things that they've never been asked to do before. They are being asked to digitize, buy new software, make new workflows, create services, when traditionally the courts have not been a service-generating government agency. At the same time, their budgets have been cut and their staffing shortages are replete. And I think this has created, by and large, three major structural problems. First is that courts struggle to adopt modern technology practices. Second is that new technologies are siloed from other systems. And then last, vendors are limiting due process, innovation, and transparency in the courts themselves. And now I'd like to unpackage them each at a time, because within these challenges, they are opportunities for us to be able to move forward on the people, process, and technology that undergird these digitization efforts. So, how can we change? What is it that we can change? First off, we can change the people that are in the room. We can change how courts conceptualize their tech stack. And last, we can change the process of purchasing technology itself, this whole idea of government procurement. So how do we get the right people into the room? For the most part, I think no one is surprised by this. Courts are little c conservative institutions. Change comes slow. Sometimes it is painstaking. But there's other reasons why this is the case. As I already said, there are these budget cuts that are happening. There are staffing shortages. As courts want more IT staff, they have to compete with what people are paid in the private market, which is always going to be substantially more than what courts are able to pay their technical staff. At the same time, throughout the US and most of the Western world, we have aging civil servant populations that are worried that automation and technology efforts are going to cost them their jobs and their retirement. Even with progressive courts, the ones that are out there, they're experimenting, they're trying to innovate, they're trying to do something new. They are still limited on what they're able to do, because most of those people have a legal background or they have a library sciences background, and they're not trained as technologists. So they're learning on the job, and they should be rewarded for the gains that they've been able to make. But it does put a cap on what they're going to be able to do just based on the training that they have. Meanwhile, younger people want to be working in areas of our communities that are having more social impact than ever before, especially with millennials, and that's even more true with the upcoming Gen Zers coming into the work market, but they don't have a place to start. And so what the solution is here, we think, is to create professional on-ramps to courts for technologists and designers. This is something that exists in executive and legislative branches around the country, but is yet to exist in the judiciary. which is what myself and Tanina Rostain at Georgetown Law are working on developing. We are just about to kick off the Judicial Innovation Fellowship, which will take mid-career technologists and place them in state and tribal courts around the country to work on access to justice issues, those projects that are going to improve the public's trust and confidence in the courts themselves. What we're able to do here is begin to help courts focus more on those access to justice issues, give them the muscle to help push projects over the edge, and then focus on replicable and scalable projects that we're then able to take to other jurisdictions. Because a lot of the pain points that we're talking about exist, regardless if it's in Biloxi, Kansas City, or in Portland, Oregon. And by doing this, we begin to push a new type of human capital into courts that previously was unattainable, primarily due to cost. And that begins to ferment what I think helps us with the other two areas of improvement that I'm going to talk about. So how do we ensure technologies integrate with other systems? For the most part, what I've been able to see is that court technology projects are primarily treated as discrete projects. Whatever that one little intervention is that's supposed to happen, say a e-filing platform for domestic violence cases, that is what it's supposed to do, and that is where it exists. But what that fails to do is it takes into account that that one piece of software lives within a larger ecosystem. So what ends up happening is you build a filing platform, or you build a filing portal that doesn't connect to the data collection. You have e-filing that doesn't have built-in self-help resources, even though they might exist somewhere else on the internet. You have virtual hearings that don't connect to calendaring and scheduling programs that the courts are already doing. All of this lack of communication between these different forms of software are limiting the functionality and impact of the digitization efforts that are already going on. So when we think about what we can do to solve that, is we need to reconceptualize what court technology and process is. We need to do so holistically, and we need to think of it as an ecosystem. So at the top of the talk, I talked about the 4 layers of innovation. You have the information, trust and consent, common tech, and services. And this is the technical framework for what is a digital platform. This is how software builds on itself to create a more vibrant digital ecosystem. And this is how courts need to be thinking about technology as well. It's not enough to think about the discrete project that you have going on. It's about thinking about what those dependencies look like across these other layers of technology within the court's tech staff itself. Doing so helps us think about these dependencies, helps think about how we can build on infrastructure that we already have, but it also increases integration. Not only do we start up new programs, but then that new program can create data that can speak to the case management system. It can speak to the e-filing portal. And right now that's not happening in a rich enough way, and it's hurting the functionality and success of ongoing court technology projects. And then last, how can we make vendors better? Courts are not going to be software companies. We should never expect them to be software companies, even though we do need them to increase their ability to internally be competent around technology issues. So this means that they're going to be reliant on private companies going forward for their case management system, for notification programs, and so on. However, the way that procurement rules have historically worked is that they're really good for tables and chairs, and they're really bad for anything that has an embedded opinion. And software has an opinion. So the procurement rules that we have are not doing a good enough job being able to assess the type of programs that courts are trying to buy. Now, the most obvious example that's gotten a lot of press in the last couple of years is that around risk assessments. This idea that you can have an algorithmic tool that can tell you what the outcome should be in a bail hearing. Should someone be held or should someone be released pending trial? A lot of those tools are coming out of private companies that use IP protections to make sure that the courts, the defense, and the prosecutors can't actually see what's underneath the hood, which should worry us in regards to both the transparency we expect in open trials, especially within the United States, but it also bother us that as a purchaser of these programs, we don't actually know what it is we're purchasing. And this has gotten some governments in trouble, where companies promise that they have AI under the hood, but really what they have is a bunch of people in front of computers, and it's just normal intelligence. There's nothing artificial about it. But yet these are million-dollar contracts that justice agencies are signing up for anyhow. So when it comes to this, we need to be thinking more broadly about what procurement can be. And I think that there is a model for that. Maybe my chat is not wanting to work, or my slideshow doesn't want to tell you the solution, but I will tell you anyway, which is that RFPs can build off of sustainable procurement models that have been used to help governments buy technology for environmental, labor, and diversity reasons, and we can push that into the human rights space. We need to think about procurement as a tool to protect people's human rights. This can help us think through the way that RFPs are designed, the requests for proposals by courts, as well as to think through what the proposals actually mean. What are people actually saying when they're talking about how they process data? What they say when they're talking about they have APIs, they have application programming interfaces, that software that allows data to move between other pieces of software. Doing so can help us defend against interoperability, or rather defend against lock-in, as well as improve interoperability. As well, if we talk about data privacy and processing, then what we have there, oh, there we go, a little late to the party. It also gives us the opportunity for source code validation. So seeing into the transparency issues that we currently have, if we take a human rights-based approach to procurement, then asking questions like this during the procurement process not only helps courts do right by their budgets and their administrative teams, but it also helps improve public trust and confidence by avoiding some of the worst possible outcomes for court tech, which is what all of this is ultimately about. Successful court modernization is going to require a holistic approach that takes into account the people, the processes, and the technology that are all coming together to try to digitize courts and improve access to justice here and abroad. This respects the needs of courts and what they're expected to do within a functioning democracy, but it also helps defend the rights of court patients who are ultimately going to use that tech. And ultimately, that is what we need to be focused on. So with that, I thank you for your time. This has been an absolute pleasure, and I'm looking forward to what the other panelists have to say. Thank you so much.
Awesome. Thank you, Jason. So now I'm going to turn the floor over to Amy.
Okay, so does everybody see my first slide? Are we good?
Yes, looks great.
All right. Okay, good. Okay, so what points I want to cover is, first of all, thank you. Thank you to Dan, thank you to Jason. I really love how you laid out a couple of key issues that I think are really important. Number one, breaking down silos, making sure that everyone is at the table, super important. I really appreciated that. And I think the other thing for us to think about is how with technology comes power, right? And with that power comes responsibility. And that's become a theme for ODR. So what I'd like to do, the points I want to cover in my 10 minutes is I want to do sort of just explain a little bit functional analysis and situate ODR within justice tech. So within those layers, there's something called online dispute resolution. And to kind of give you a bit of history, I suppose, a quick history of how it came about. And then the evolution of how it moved from private to public, which actually is very important to the story when you think about procurement and these kind of public-private partnerships and how they've developed. And then finally, I want to emphasize research, the R's as I like to call it. Research to revise programs, learning what works, what doesn't work, and then to reimagine access to justice. So first of all, what is ODR? Just to give you a quick rundown, it's any technology used to prevent or resolve disputes. Now, this has been around a long time, and some of us older people have been looking into this for like 20 years. And it really developed in the late 90s and has really flourished. And of course, COVID has been a jumpstart on ODR. It can include problem diagnosis and wizards at the outset. It can also include negotiation, online negotiation portals. You can even have assessment tools and predictive analytics built in, which can be very helpful for self-represented litigants. You can also have online mediation, and finally, online hearings, online arbitration, or e-courts, online court. Another way to think about it is modular technologies. Some of my more recent research has actually looked at intelligent legal tech and really almost like Legos, right? Different pieces that might fit in for different contexts, fitting not the forum to the fuss, but fitting the technology to the fuss. So building what works for a particular problem. Things like case management, communication tools, also triaging, be able to figure out when there's a real problem and you might need some other third party to come in. Advisory tools, decision support, and finally agreement technologies. lots of different types of technologies that some of us have been looking into in this world of ODR. Why? Quite honestly, access to justice. We have a justice crisis. People do not have the access to remedies that they need. I personally stumbled across this long time ago when I was just teaching consumer law at University of Colorado, and I thought, why do consumers get such a bad deal? And I went and I did my own empirical study, and I really learned how hard it is for consumers to get remedies. And so I stumbled literally onto ODR because I was trying to figure out a better way. And it turns out that's true for a lot of us. Why? Because litigation face-to-face, it's expensive, it's difficult. The Consumer Financial Protection Bureau also did a study in consumer remedies and emphasized the importance of mobile access. Using your digital device to access remedies can be really powerful for individuals in the real world. Also ODR, because it can bring in online neutrals in a way that can be more easier and cheaper and lower those hurdles to remedies. Face-to-face, it can be a hassle. It takes travel, it takes time off of work. There's a lot of difficulties that come in with in-person hearings. That's even true for like small claims court. Also, asynchronous ODR allows access off hours, right? This opportunity where you can maybe get a remedy, you can have an online chat or even an online mediation at a time when the courts aren't open. And so slowly but surely, these ideas were building around a functional analysis. The function to expand access to remedies, to expand access to justice. It's really a problem-solving exercise. How can we, and along with the fabric that Jason explained to us, how can courts help create tools for problem solving? And the other thing with ODR, it can adapt for language, physical, time differences. In the UK, I had the privilege, it was a lot of fun. I went over to London, which is always fun, and we had a roundtable about Her Majesty's Online Court. It also can help governments save money. And you better believe that austerity was a big reason for Her Majesty's Online Court. Again, these wizards and chatbots can be very helpful for self-represented litigants, especially. Another piece that has become quite interesting is this quote unquote space that computer mediated communication can ease stress, because it can be very, if you've always had a bad deal, if it's always been really tough to go to the courts, if judges are not something you think of as your friend, if it's stressful for you, it actually feels a lot safer to communicate behind your computer. And a lot of us, we need different modalities. We need different technologies. We need different Legos. We need different problem-solving tools. And this can be possible with a sandbox approach to court, to thinking about these different processes that might fit into the layers Jason talked about. Also, text-based processes can actually, there's a new research showing that it can ease face-to-face biases because you don't see the other people at all. It's purely text-based. So that's kind of the setup, right? In terms of how did this whole develop? Well, slowly but surely, that's, 20 years ago, this is all kind of developing slowly. We see this developing mainly in private companies. So one of the big examples that is, of course, always cited is eBay. In fact, that was me when I was doing my empirical research on consumer law. I literally took my spring break to fly out to Silicon Valley and to meet the guy, Colin Rule, who created the system for eBay. And I just wanted to learn everything I could. I was like, Curious George goes to the Silicon Valley to learn everything about what they're doing for consumers. And it was this idea of creating a process that was consumer friendly, that helped both the business and the consumers. Consumers were able to get quick remedies, and the business was able to get more customers, because it turned out that the more consumers use this process, they were willing to spend more money because they trusted eBay. Well, fast forward, and now we see all of these new online companies, they're software development companies that now are creating these portals that are being used in the courts. And Matterhorn is a great example. Matterhorn is operating here in 16 different pilot projects in Ohio alone. In Michigan, many, many more. And in fact, Jason can tell us about that. In Michigan is where it was actually started. So it starts private. We see eBay, we see Amazon, private companies like Fair Claims, eJudicate, it goes on. Being a complete ODR nerd, I actually do keep a chart, so you can check it out on SSRN, posting all these different types of platforms. But now we start to see the public-private partnerships. And this links directly with what Jason was talking about. Now we see where you have the RFPs, and now the courts are hiring companies like Tyler. Tyler, incidentally, was part of, well, Modria, basically, which was spun out of eBay. So we are talking directly out of private to public, became Modria. Modria got bought out by Tyler. Tyler Technologies is now in most courts around the world. Matterhorn, another one in many courts. TurboCourt is another example. You're seeing a lot of these public-private partnerships. In the US, many of these e-courts, now Utah is different because it's homegrown, it's open source, but the rest are all private-public partnerships. I did an article in eCourts in 2019, and there were quite a few, but boy, oh boy, there are many more now. We see just this huge growth in looking at the evolution. Also, around the world, you have Canada, China, the UK, the EU, also with their platform for ODR regulation. It is really an exercise fitting the tech to the fuss. Some of the main areas: small claims, tax appeals, traffic tickets, family, condo, and landlord. US, this just gives you a glimpse from 2020. I would argue it's much broader now. Landlord tenant has exploded in COVID. But I think it's important for us. There's this huge run up, the bright shiny new toy is there, but we have to stop and say, wait a minute, is it fulfilling the promise? Is it expanding access to justice? And this was concerning to me. This was from the Innovation Center with the American Bar Association, and they were looking at different features of ODR systems. Look at this slide. There are not enough yeses. There are not enough yeses. This should concern you that we're not living up to the promise of ODR and what it could provide for access to justice. We have to ask who? Does it actually expand representation of the people who need it the most? There's an example with mass lenders actually using the program in Utah, and it's actually becoming helpful to the lenders instead of the debtors. That's a problem. We need to stop that. We need to do more research and figure out better ways. How? Looking at the process. Do people drop out? Is it frustrating? Well, then it's not useful. What? Are people getting different deals? That is another important piece to the research. So my own survey, I did a survey before COVID, and I'm just going to give you sort of the outcomes. And some of the big lessons that we learned in the empirical study was value. First of all, people want to make sure it's actually providing value. Is it possible to provide? Yes, but it's got to be user-centric, human-centric design. Privacy and trust, always important, not always there. Something we need to build, as Jason mentioned. Live assistance. All of these programs, especially when they're just getting off the ground, you need helpers. Clear consent, forced ODR can be problematic. User-centric design, again, easy and intuitive. People will drop out and you will not have individuals completing the process if frustration develops. There is a digital divide. It is not gone. COVID shined a light on this. It's also important for us to think about this. A long time ago, I argued for court kiosks, and now we are seeing them. In fact, there was an article, Bloomberg, just yesterday, talked about justice buses, right? Bringing justice to the people with technology, with court kiosks, having tablets available so individuals are able to participate in getting remedies. But there's no quick fix. Often there's underlying problems. For example, when it comes to debtors, abusive lending can be the problem as well. Very simple. This is a picture of a court kiosk in St. Louis. Again, it's not simple to design and build ODR systems that are secure, equal, confidential, accessible, accountable, fair, and legal. We care about security, but we got to do it, because ODR has this amazing potential to be built into those layers Jason discussed. And user-centric human design, we break down silos, we get everyone to the table. We have to be willing to research, revise systems based on that research, repeat that process until we get it right, so we can reimagine access to justice. I invite you in my last minutes. There's ethical guidance being offered. In fact, ICODER and NCTDR have issued guidance. And hot off the press this, I'm the co-chair for the ODR task force with the American Bar Association. We finished our guidance for ODR and we will be publishing it very soon. So stay tuned. Again, thank you so much for your time. And I'm really excited about further discussion.
Thank you very much, Amy. And I want to remind everyone, as we see a lot of good questions coming in the Slido, so we're going to have a bit of time for some discussion, but we have one more presentation. Oladeji, take it away.
Great. It's nice to be with you all remotely. So Jason and Amy are grappling with what the implications are when disputes are resolved online. With my time, I wanted to spend the next 10 or so minutes discussing a survey that I recently published, empirical based, that's collecting and drawing on experiences that ADR practitioners, alternative dispute resolution practitioners, so mediators, arbitrators, and many others have had throughout the pandemic relative to pre-pandemic rates in using technology in their practices. And I think this is a good connection with Amy's presentation, because Amy presented a lot of information around pre-pandemic trends. And so I kind of wanted to connect Amy's discussion with now what we're seeing, but ongoing or perhaps post-pandemic trends as well. And underlying so much of this, whenever we talk about online dispute resolution, is this balancing act between fairness and efficiency, right? Being in online spaces, the aspiration is to increase efficiency, and sometimes that increased efficiency can lead to tensions with fairness, especially in the access to justice lane. So a key aspect also of what I noticed Jason touched on is this conversation around integrating technologies with other systems. And Jason, just to quickly comment on that, I think that is this important piece that can increase both efficiency and fairness in a way that those two don't have to be in tension with one another. So I also just wanted to share that data that I've been talking about here. And as I share this data, I think we should all think about, right, is online dispute resolution a Peloton-esque fad, right? Is it something that is only within the context of the pandemic? Or is it more of a e-commerce trend that has the possibilities to go beyond the pandemic and stay-at-home orders? So I'm just going to share my screen here. And can I get a thumbs up? Hopefully everyone's seeing this. Great. Okay, so this data is collected from, as I mentioned earlier, alternative dispute resolution practitioners. And so what we see here is that there's a drastic change from 2019 and 2022 rates. So the x-axis is really covering 2019, which is pre-pandemic. 2022 is shorthand more or less for the end of the first quarter of this year. And so what we see is both with, whether it's with colleagues or with parties, people who are practitioners in this space are doing their work dramatically less frequently in person. There's been a drastic transition away from in-person interactions and towards online spaces. And, you know, so this report really tries to filter out demographic differences in how the field, our field, is engaging with technology during the pandemic. So one of these key differences that I think this data illustrates is based on the region that an individual practices in. There are differences to their level of engagement with technology. And so what we see here is that rural communities have perhaps the greatest contrast to suburban and urban practitioners. Rural communities through the pandemic have had higher rates of in-person meetings with colleagues and with parties. And at the same time, suburban and urban communities have more or less tracked the same trends of limiting and reducing the amounts that they interact with colleagues and parties in person. So going back to what Jason described around, and what Amy also described around these ODR platform providers, the real demand is going to be coming from urban and suburban practitioners. That's where there has been this drastic transition away from in-person meetings. And so to me, this data is really critical because we have a better understanding that rural communities, even though they are meeting at high rates, that those high rates are dramatically less than suburban and urban practitioners. So for ODR platform providers, the key demographics where the growth is really going to come from with online dispute resolutions, it's not going to be in rural spaces. It's going to be from large urban centers and sometimes the suburban practitioners. So the next piece that I thought was worthy of sharing with everyone here today is just how much different practitioners are interested in engaging with online spaces into the future. Here we see the x-axis is 1 year into the future, right, 2023, or 5 years into the future in 2027. And I wanted to zoom in specifically on mediators because that is typically the largest representation of this field in dispute resolution. And we see across the board, but especially with mediators, that ADR practitioners are interested and anticipating conducting their online work predominantly online into the future. The change and the dramatic change comes when parties are asked whether they want to conduct their work exclusively online. And so with exclusively online, there's still some demand for it, but there is also dramatically more resistance in conducting their work exclusively online. And when I see this data, one of the key takeaways is that resolving disputes online is going to be a complement, right? It's going to be a complement for in-person interactions, whether that's courts or with dispute resolution practitioners. And it's not a replacement necessarily of these in-person proceedings. It's going to serve as a complement to those in-person systems. And so as we're navigating this transition between going from exclusively in-person pre-pandemic to being fully remote through the pandemic, and now having more and more hybrid interactions where technology is complementing in-person proceedings, I think that's the key question. How are courts and dispute resolution practitioners going to most effectively use technology to complement rather than replace in-person proceedings? How can technology be used as a supplement for these interactions? And so the last slide I wanted to share here is this, going back to the regional split in terms of who wants to use online systems, whether it's predominantly or exclusively online, into the future. And so what we see here, unsurprisingly, rural communities relative to their urban peers have less of an interest in working, whether it's predominantly or exclusively online. But it's the suburban and urban communities that, looking into the future, are more interested in this piece around working predominantly online rather than exclusively online. And so, you know, with the start of my first 10 minutes, I kind of just asked whether online dispute resolution or online systems for resolving disputes is more of a pandemic fad like Peloton, or whether it is more permanent like e-commerce. And at least with what the data has shown us so far, it seems that into the future, at least 5 years into the future, it's online dispute resolution is a fad if we frame it from working exclusively online. But when practitioners and courts have the opportunity to complement in-person proceedings, it's not a fad at all. Like this is something that more and more practitioners and courts are trying to interact with in order to provide a complement to pre-existing in-person proceedings. So those are just a couple of snippets of this piece that I published earlier this year, and I will leave it there. So thank you, everyone.
Thank you, Oladeji. So we've got a bunch of great questions that have come in, so I'm hoping we can take a few of them. The one that got upvoted the most on Slido was one from John Mayer at CLE, who's been active in this space for a while, but he's asking, well, but could the courts be software companies? And so he proposes maybe a consortium of courts paying dues, creating open, free software. Jason, why don't we start with you? I mean, do you see anything like that? Any sort of an approach where courts are really changing and thinking about how do we become software companies and maybe work together to do that?
So I think there's always going to be a ceiling on what that's going to look like, and it depends on jurisdiction and interest in doing that work. I mentioned Estonia a number of times because from the Justice as a Platform paper that I wrote, they stuck out as internally understanding what their tech stack needed to be the most. And they have a very impressive in-house technology development group, but they still outsource stuff at the end of the day. They can only do so much because the demands are so high on the court. So even if a court like Estonia still finds its need to outsource, then I suspect American courts will find that ceiling a little bit even lower, just because of all of the differences. Like Estonia doesn't have the jurisdictional complexities that the US has, for example, that I think makes all of this much more challenging.
Is it all right if I jump in real quick?
Please do, Amy.
Oh, sorry. Yeah,
No,
thank you. Oh, good. Okay, cool. Yeah, so so the National Center for State Courts started working on open source. This is a while back, and then also they partnered with Pew in terms of research, and then at the same time, Justice Jimenez in Utah started to really sort of work on this idea of a sandbox and a court being a sandbox and allowing for open source and creating their own homegrown process. So Utah actually created its own process and used it used open source and worked within that sort of more of a public space where they were becoming software developers. Did everything work out perfectly immediately? No, but they learned from mistakes, right? And kept sort of building. Another example is the CRT in British Columbia. The Civil Resolution Tribunal, that's again homegrown, where you had the court basically acting as the software company and creating their own system. And they also kind of create this, they use the R's in that they're constantly doing research and then revising based on that research. And then finally, the Cyber Justice Laboratory in Montreal is another example. They do a lot with open source. Parlay is their program. So I really appreciate that question because we're seeing examples of it now happening. So thank you for that.
Oladeji, I think I'd ask you a version of this, but I mean, so some of your research looking at these differences between in-person and online interactions, I think sometimes when I hear people talk about improving access to justice with technology, some of the pushback I hear is like, technology is always going to be second-class justice, right? It can never do what we can do in person. Now, I don't agree with that, but I've been drinking the Kool-Aid for a while, I guess. And so, what have you learned from your research as far as how we maybe need to think about what kind of things need to be in person versus online?
Yeah, I think a lot of it depends on age, it depends on background, it depends on the part of the country you're operating in, right? So people in the ADR space often talk about digital natives and digital nomads, and I think that is helpful in analyzing your question, right? So people who are digital natives who were born with full immersion in technology would have greater likelihoods to have future disputes that they have resolved online. They have more comfort in these online spaces, right? There's so many different examples. It can be social media and the complexities of social media, but the level of comfort people have in sharing their data online through social media oftentimes depends on that age consideration. And younger people are more accustomed and more habituated with that. And so I anticipate that there would be a generational divide in that spirit. Similarly, with some of the data I ran through today, rural communities versus urban communities, I think if, as the data showed, rural communities are more more accustomed and more acclimated with these in-person interactions, they would view online spaces, online dispute resolution as not as valuable to them. Whereas if you're in an urban community and you have issues with transportation, you have issues with childcare, being remote can provide a lot of more flexibility for your needs. And in that situation, it wouldn't be second class at all. It would be, you know, more for first class than anything else.
So another question that came up here on Slido is talking about, Damian Reel posted about, talking about universal standards. And so he's affiliated with the CLE project. There's a lot of different projects thinking about standards. Anything like that happening in courts where we're seeing, like, and who's leading the charge? I don't know if you want to start on that, Jason, and maybe Amy and Oladeji have ideas.
I mean, the big national project in the US is done by the National Center for State Courts, the NODS standard, the National Open Court Data Standard, I think is the acronym. And that's maybe the beginning and the end of the list. I'm happy to be corrected if that's true, for that's happening specifically within courts. Damian's work with Sally is more broad than just courts, which is why I don't include it there. No, I mean, we need to be doing more, but we also need to not fall into the, there's an XKCD comic about how we need to build a better data standard, and then all we end up doing is creating just another data standard, and we can't agree. Then we have like 14 competing data standards. That's not the trap we need to get into. I think we just need to agree which one we're going to iterate on and improve. But we do need to see improvement in data standards around, say, open APIs. Like, what does that documentation look like? What does the functionality of that API look like? I don't think I have seen that yet. If it exists, it's not getting promoted to the degree it needs to be. And so that's one clear place for improvement that I haven't seen much effort on so far.
So a while back, there was some movement within ISO, the International Standards Organization. I'm not quite sure, where that landed, but that's one thing to sort of watch. Also, if you're talking specifically about ODR, we do have some movement. The International Council for Online Dispute Resolution and National Center for Technology and Dispute Resolution just recently put forth new standards for ODR, but of course that's specific to ODR, but does include ODR in the courts. Also, the American Bar Association, the task force I mentioned, we had 3 working groups, and one of the working groups was specific to the courts. And so we just finished, and we're going to be publishing soon, the guidance. We're calling it guidance specifically because, you can't, how do you enforce it, right? And so at this point, we're really focusing on guidance, and some of those do apply to courts in particular.
And I was thinking of technical specifications as opposed to like programmatic specifications, what Amy's talking about. And I would also should add that OASIS has ECF4, which deals with e-filing standards as well, for as far as technical standards in the courts is concerned.
So there's a question here from Lainey Feingold about asking, can someone speak to efforts to ensure that court technologies are accessible to disabled people? Does any one of you want to, I don't know if you want to just raise your hand. Amy, you want to jump in? Go ahead. Yeah.
Unless Oladeji, did you want to jump in? Because, oh, okay. I mean, this is huge. I think we've got to do better. Lainey, thank you so much for the question. Lainey's been a leader. Dave Larson's been a leader. This is really an important area. We need to do better. If you remember that slide, the yeses were not very robust on whether things were accessible. And I think there are efforts. We've got to do better. That is actually one area, the task force that I mentioned earlier. We have quite a few pieces that are specific to disabilities and making sure that these processes are accessible, not just ADA, but going beyond that and really thinking about access to justice. So thank you for the question.
And for technical standards, to jump on there, there's the WCAG standards, which is what the federal government expects websites to be built on for accessibility when it comes to screen readers and other forms of online access. So that should just be tossed onto that accessibility access as well.
So we got a couple of questions here about court security and the tension between protecting courts against hacking, but keeping them public and open. I mean, this goes to the data question. It's interesting, like here in the US, there was a lot of outrage about when France passed some laws about restricting use of analytics. But here in the US, the data is not available to us anyway, behind paywalls, and you can't get it in courts. But I mean, So Jason, you spoke this a little bit, but I mean, well, how do we manage this? How do we keep courts public and open? And in fact, don't we need, isn't more than ever, we need that data to be available to everyone, don't we? I mean, how does this play out?
Ricardo is somewhere on this call, and we were talking not that long ago about this. And the metaphor I came up for was that there's an intersection without stoplights, where on one lane there's a barreling car that is the open courts car, and then in the other there is the privacy car, and they are headed right for each other. And I'm not sure what the right way to avoid that collision is. I think it's going to be difficult. I think what the data is going to look different. Just the idea of privacy in courts is completely different. Previously, you had to go to a physical courthouse to sit in on a hearing. Now you can be anywhere in the world, and that changes structurally what we consider a functional form of privacy that no longer exists. And we're going to have to think long and hard about that, because there's implications to this, especially when we think about how personal data is aggregated with other data sets, and then it's used against us in a variety of different ways. So we can't go forward acting like open courts look and have the same ramifications that they did 20 years ago, because they simply don't. So we do need to be thinking about how we build in those protections. And there's some projects that are doing this, right? There's the Clean Slate Initiative, which is automating the expungement and sealing process in a number of states around the country. There are programs in eviction court to be able to hide those records as well, so people can get housing after they have been evicted. And so we're beginning to see inklings that we're thinking about this, but we do need to drastically mature the way that we think about privacy and open court data.
Yeah, I would just add on, I'm always curious to just think about jurisdictional differences, cultural differences, right? So if I'm in Southern Illinois, well, I think about my data privacy in the same sense, on the same issues as someone in Northern California. And so I don't have answers on that. I just think it should be an important piece of the conversation, that jurisdictional considerations will, standardization is hard in the US when there are such dramatically different cultural understandings of privacy and data.
All right, so I think we have time for one last quick question. I just want to ask about, I think, sometimes when we think about innovation in courts, then we're thinking about innovating around dispute resolution. But of course, there's also big opportunities to help prevent disputes, help people understand their rights. And I think, Jason, you referred to different self-help tools. It's interesting, courts are kind of in that game to some extent, but then there's legal aid organizations, there's even some legal tech startups. I mean, how do we figure out that balance as well? And I mean, a little bit like that when we look at the British Columbia Civil Resolution Tribunal model, that kind of even is looking at, we don't want to think about adjudication anymore, right? What are the different ways we can do things? So, Amy, I see, do you want to jump in on that?
I would, thank you. I actually, so if anyone's interested, it's in my slides, or I can share it. I actually just wrote an article about that, looking at sort of a modular system and how we might do a better job of dispute prevention and giving people information and self-help mechanisms, because the technology's there. I mean, there's a lot of really great things we can do. The sandbox approach I mentioned earlier, and innovation where you work together can be really helpful. And I do think there's movement for that. I know back, gosh, I guess it was before the pandemic, National Center for State Courts was looking into some of these technologies also, and how you might actually use AI and use different chatbots or natural language processing, and sort of thinking about these different opportunities for tools like Legos, right? And providing you different ways. To your question, I also like that you mentioned, whenever we say, saying second-class justice, there's also the truth, which is the fact that most people don't even go to court, right? And so when you're saying compared to what is the question? So we also need to think beyond the courts. We need to think about local community centers. We need to think about other places that people go for help, AG's offices, complaint filing, BBB, different ways that we might be able to create technologies that link people to remedies, because the courts are not the only place that people go. So I think we have to really think about these technologies with a broad scope, and absolutely we should, and we need to do better in terms of different problem solving mechanisms.
Jason, quick thoughts on that, and then I'll go to Oladeji.
Yeah, there's a double-edged sword with all the digitization that's going on. The good side of it is what Amy's talking about. While we're thinking about adding these new processes and technologies, it's a way for us to rethink what court looks like, or what justice looks like, what a remedy looks like. But at the same time, we also run the risk of digitizing bad processes. And so it's going to be important for us to remember that in our path, in our pursuit to digitization, that we're not literally coding all of the bad things that happen in courts, all the bad process, all the biased process that happens in court. And so that's where I'd like to leave the note.
Oladeji?
Yeah, just a quick comment on mine. I think, we have this long history where the courts have been kind of this fixed space where you go with your lawyer and you litigate and you resolve your disputes in this physical and fixed space. And I think in this new online space, there's this valuable opportunity that all courts should really be thinking about. How can we redefine our role? And as Amy was alluding to earlier, one key piece of that is allowing potential litigants, not actual litigants, but allowing potential litigants to be fully informed of their rights without having to go through a lawyer or an advocate or counsel. So I think in this online space that courts are exploring increasingly, the Justice Administration overall should really be thinking through how can they expand their definition of a tribunal or a court.
Well, thank you very much, Amy, Jason, and Oladeji, for spending this time with us. I wish we had some more time to talk about this. Hope we can continue the conversation. Thank you for all the great work you're doing in this space. Thank you to everyone on Zoom for joining us. Thank you in our live audience for people who are joining us. Thanks to Elise Wu and David Scheckman, law students here who helped organize this event. We have another event next week, a hybrid event. We'll have some more of the speakers actually in person here next week. So really great conversations here today. Great comments on Slido. Thank you everyone for joining us, and we look forward to seeing you again soon.